Hello everyone, welcome to a special episode of Atheist Tea Girl. No funny of the week, no funny stories. This is another unhappy one.
So gender is just a social construct, and believing in God is a crutch. When you mix them together and give them a whirl, what do you got? Atheist tea girl!
Wednesday, October 8th, there was a lot of talk on social media about the Supreme Court and a case that might decide if it's okay to fire someone if they are trans. There were people asking what could be done about this. There was worry that the next day people would be out of a job. But the next day and the week since have been filled with silence. Why is that? When will we know the fate of this case? How is this even something the Supreme Court is deciding on? I'm hoping to answer these questions in this video. Part 1. The Supreme Court and its processes. Before we can answer why we have heard nothing and why the Supreme Court is discussing this question, is it okay to fire trans people for being trans? There are some things about the Supreme Court that must be explained. I'm sorry some of this is intro stuff you already know, but I've had questions about it, and I do not want to assume that everyone has this info. A case first goes to the lower courts. This is generally a federal court. It behaves in a typical trial fashion that someone who has watched any of the 100 or so courtroom dramas on TV would be familiar with. The jury or judge makes a decision, and the case is complete. After the case, the losing side is upset they lost or feels they have had a bad decision, so they make an appeal to the U.S. Court of Appeals for a better satisfaction of their case. This is not a rehashing of the whole case, but generally an appeal based on what the petitioning party feels was something overlooked or wrongly decided based on current laws and the history of previous court decisions. Without getting into the whole details here, the Court of Appeals has three options. 1. Not take the case, in which case the original ruling stands. 2. Take the case and rule that the lower court was correct, where again the original ruling stands. 3. Point out an error in law or procedure that the lower courts made. This can then end up with two options. A. The court rules that while the error was made, it would not make a difference and the original ruling stands. Or B. The court rules that the error caused a miscarriage of justice and the lower court decision is either 1. Overruled and then decided for the person who appealed to the Court of Appeals, or 2. Needs to be sent back to the lower court for retrial, often with instructions on how certain parts of the case need to be handled. After the Court of Appeals has gone through and made the decision, the losing side of this appeal may want to have an appeal of the ruling made by this appeal. There's really much more, including further appeals inside the Court of Appeals with different judges or more judges, but we're streamlining it. They then write what is called a petition of writ accessory, which is basically a fancy way of saying they ask the Supreme Court to take a review of the question or two they feel was inadequately or wrongly answered by the lower courts. The Supreme Court receives thousands of these requests a year, but typically only hears about 80 of them. Law clerks of the court review these petitions, and one they feel might be a notable case or one in which appears as if there's a genuine confusion in lower courts on how to proceed are suggested to the Supreme Court justices. Then in a meeting, the justices vote on if the case should be heard or not. A vote of 4 justices must vote yes for a case to be heard. It is then scheduled for arguments at a session of the court. The Supreme Court has a session that runs October through June/July. They usually hear 1 to 3 cases a day, 3 days a week, for 2 weeks. Then they have 2 weeks of recess. Then repeat the process. This alternating between hearing cases and recesses goes on between October to the middle or so of January. This might seem like an easy workload. Work 3 days a week for 2 weeks, then 2 weeks off for 4 months of the year. But in recess and during the times the Supreme Court is not hearing cases, they're spending time reviewing the cases, making decisions on what cases to hear, writing opinions on the cases, and other pieces of work needed. I am cutting a lot about this out of the video I'm recording. If you're wanting to know more about the process, and I find it interesting, but I can imagine some might find it boring as paint drying, I would suggest following the references whose footnotes are on the screen right now. I will include a link in my YouTube notes with the script and the references mentioned here. So again, streamlined. The process is that the court will accept a writ, and during the first part of the case, both sides must send in briefs about the questions in the case and a summary of the case. They point out which laws and previous Supreme Court decisions apply to the case and why they feel the laws and opinions are in their favor. In addition to the interested parties filing paperwork, other groups of people not involved in the case who have an interest in it also send in briefs. These are called amicus briefs, or friend of the court. They will generally give info on who is filing the brief, why they've taken an interest in the case, and either will point out points of law that the interested parties didn't mention, that they feel are relevant, or will explain what kind of impact the decision in this case will make on them. After all the paperwork is in, the court schedules oral arguments. These are the court sessions done between October and January. Each side gets 30 minutes to argue their case. This is not a normal courtroom argument, but instead, while speaking as to why they feel the law is on their side, the speaker is usually interrupted by multiple questions from justices. These questions and the answers cut into the 30 minutes the speaker has. The Thursday or Friday after oral arguments, justices have a closed meeting of the justices. No clerk, security, or anyone else is allowed to witness these. They vote in order of seniority. After the vote is made, the side with the most votes selects someone to write the majority opinion. The side with the least votes selects someone to write a dissenting opinion. The Chief Justice picks the person to write the opinion on whatever side of the case he or she is on. In addition, the justices are free to write opinions of their own. In the case of a tie, the lower court's ruling stands. After the opinion is written, all the justices write off on it. There may also be some concurrent opinions which basically state the vote is right, but the majority's opinion is wrong as why the vote should be this way. In some cases, disagreement of how the majority opinion was written has caused justices to change their vote, making the dissenting opinion the one with the least votes, now the one with the most votes, and now the winning ruling. Until it is made public, justices are allowed to change their votes. Finally, the opinions are released. When they are released is a mystery. Sometimes, in the cases of a unanimous decision, the decisions are released as soon as December. In cases where the decision is big in impact or was contentious, the decision and opinions are not released into the last day of session in June or July. At the releasing of the opinions, the justices are allowed to read as much of their opinions as they choose to. Part 2, the case. The Supreme Court actually heard 3 related cases that they combined on October 8th. Altitude Express versus Zarda, Bostock versus Clayton County, Georgia, RG and GR Harris Funeral Homes, Inc. versus Equal Employment Opportunity Commission. The first 2 had to do with being fired for being gay, while the last dealt with trans people. For this video, I will focus on the RG and GR Harris Funeral Homes, Inc. versus Equal Employment Opportunity Commission, which I'll shorten to trans employment from here on out. Amy Steffens worked for Harris Funeral Home. After about 6 years of working for them, she came out as a trans woman. She notified her bosses that after returning from vacation, she would be dressed as a woman. She is using this vacation time as a period of time to start off in a comfortable environment. Her boss and owner of the company, Thomas Roust, fired Amy. In depositions given to the case, he stated that it would have violated the company's dress code and disrupted the grieving and healing process of the clients mourning the loss of their loved ones. He also mentioned that he had concerns for the safety of his female employees as they would be forced to share a bathroom with him. I'm going to do my best to only use she pronouns and use Amy's correct name, but at times I may use male pronouns to point out the views of some of the parties regarding trans people and whether a person can change gender. Amy contacted the Equal Employment Opportunity Council, and they stated that the Thomas Ross violated the law. This case went to trial. The EEOC focused on two places where they stated the law was violated. Number one, that in firing Amy for being trans, they were violating her Title VII rights. This is part of the 1964 Civil Rights Act that dealt with discrimination based on race, color, religion, national origin, and sex. They claimed that firing for gender identity was going against the sex. This argument was not accepted by the court as valid. Number two, that requiring Amy to wear a man's uniform, they were discriminating based on gender stereotypes, and this had been ruled as illegal under the appeals court ruling in Price Waterhouse versus Hopkins. This case had determined that a person who had been passed over for promotions because she did not fit the expected demeanor for a woman had been discriminated against. The district court did state that Amy had suffered discrimination under this part of the rule, but that her rights were subordinate to the rules put in place by the Religious Freedom Restoration Act. This was a law passed overwhelmingly by House and Senate and signed into law by Bill Clinton, and was passed in reaction to a group of Native American Christians who had been prosecuted and convicted for using peyote in their ceremonies. The history of law can be really wild. Because the first argument had not been ruled a violation, and the second was ruled as being overruled by the RFSA, Amy lost the case. Her lawyers appealed to the appeals court, and they ruled that Amy's rights were not violated for the gender stereotyping, but instead that the Title VII rights use of sex as a protected class did mean gender identity as well. To quote, discrimination against employees either because of their failure to conform to sex stereotypes or their transgender and transitioning status is illegal under Title VII. Thomas Ross' lawyers appealed to this to the Supreme Court, asking for answers to these two questions. 1. Whether the word sex in Title VII's prohibition on discrimination because of sex meant gender identity and included transgender status when Congress enacted the Title VII in 1964. 2. Whether Price Waterhouse versus Hopkins prohibits employers from applying sex-specific policies according to an employee's sex rather than their gender identity. The Supreme Court accepted this writ in a hearing on October 8th, where the oral arguments for this case and other two mentioned below. By the way, those two cases might determine if it's okay to fire someone if it's gay, and have their own fun and long history. It should be mentioned that the order in which the Supreme Court hears a case matters. The cases heard first are the ones the Chief Justice feels are ripe or ready for a Supreme Court decision. This case was the first one heard in this year's session. Before I close this section on the case, I thought it would be a few pieces of information that I should include. As mentioned, parties not in the case but who are interested and may be affected on it can file amicus briefs. This case was not an exception. I count 90 of them on this case. And if you really like to find out how people really feel about trans people, then I suggest to read some of the amicus briefs. Don't. For supposedly legal documents, some of them are quite religious and possibly triggering. Some that I wanted to call attention to was the brief of amicus curiae from the Foundation for Moral Law, which was filed in support of the petitioner, Rost. It is as judgmental and religious bigoted as it sounds, but does a decent job of summing up their opposition. Another two I want to point out are two different briefs from Congress. One of them is for trans people, and it has 39 senators and 114 members of the House of Representatives on it. The other is for the employers, saying that you can fire someone for gender identity, and that had 7 senators and 40 members of the House. Ross lawyers are being paid for by a group named Alliance Defending Freedom. Their definition of freedom, if their website is any indication, means allowing religion to step on others' rights. I might have to do a video on them someday. Amy's lawyers are from the EEOC. The EEOC is a federal agency that administers and enforces civil rights laws against workplace discrimination. The case started in 2013. Since then, the government's policy on trans people has shifted. The official policy is that Title VII does not cover gender identity. For each case at the Supreme Court, the Department of Justice is allowed to file an amicus brief. In addition, they are allowed to take some of the oral argument time from whichever side they are filing for to present their opinions. Because of this, 15 minutes of the oral argument was from the Department of Justice trying to argue that the protection should not include trans people. Basically, our government argued that we should be able to be fired if you're trans. Thomas Ross seems like a real charmer. He required all the men in his employment, funeral directors or otherwise, to wear a specific blue suit and a tie. He bought and paid for these clothes for the men. In the same vein, he required all women to wear skirts and other specific pieces of clothing. Why? To quote, he said that he was just and old-fashioned and believes that a male should look like a man. In addition, he did not pay for the women's clothing because, again I quote, "You women are a strange breed." After being sued by the EEOC, I was unable to determine if they meant this case or a previous one. He did start giving women a clothing stipend, one that was 62% of what the men's clothes were costing. Section 3. What now? Now that the history of the case and the workings of the Supreme Court have been explained, I'll try to answer questions that I saw being asked. When will this get an answer? It could be tomorrow, but most likely it will be on the last day of June. What are the chances that trans people will win? I cannot answer this one. Legal scholars, people who actually went to school for this, are still scratching their heads, and I've seen guesses going on both sides. Numerically, by the political spectrum, trans people will lose. But some of the reviews of the oral arguments I saw suggested that there might be a chance that Neil Gorsuch might flip based on some of the questions he did ask. I wouldn't put too much hope in it though. The law says sex. This obviously doesn't mean gender identification. Why is the Supreme Court even thinking about this? This is what the Supreme Court is made for. The Constitution set the justices up independent from other branches and with life appointments so that they did not have to worry about politics and getting reelected. Because they are immune to being fired for a decision unliked by the populace, they have the freedom to decide cases for either side no matter how big or small they are. It was decisions from the Supreme Court that started the end of segregation, allowed women reproductive rights, and gay marriages. All three were things that were wanted, but at the time would have been suicide for a politician to support. What can we do now to change their minds or influence them? At the moment, there is nothing we can do to influence them. Petitions and protests are actions meant to get the attention of politicians and let them know that a decision they are making might have bad consequences for their future political careers. As I mentioned in the last question, the Supreme Court does not have to worry about this. One of the few ways they might be swayed are amicus briefs. Generally, the justices do not read them, but their clerks do, and they do pass these on to the justices in instances where there might be something novel or interesting to add to the case. A few opinions released by the justices have had quotes or bits of briefs on them, so there is some indication that they might have a bit of sway. Unfortunately, the time for this has passed. What happens after the decision? I'm again not a legal scholar or even a student, so what I say is just opinion based on what research I have done. 1. They could rule the firing of Amy was wrong, and this gives trans people protection under already passed laws. This could then possibly be expanded to include other rights such as apartment rentals. 2. They could rule that the firing was right and in a way that states that there is no protection for trans people under the current laws. More on this later. 3. They could kick the case down the road by issuing a narrow decision that basically only applies to this one particular case. Last session, the Supreme Court did this with the case most people remember as the gay wedding cake. Masterpiece Cake Shop versus Colorado Civil Rights Commission. The question there was if it was okay for a person to use First Amendment claims of free speech and free exercise of religion to be exempted from laws ensuring non-discrimination in public accommodations, in particular creative services. Rather than answer the question, the court instead decided that some of the steps the Colorado Commission used to get the case to court were not done in the right frame of religious neutrality, and these steps actually meant that the case was thrown out in favor of the cake shop. This left the main question unanswered and to be taken up in a later case. What happens if trans people lose? It would mean that trans people do not have the same rights of protection against discrimination in employment. This decision depends on how it was worded, could also expand the lack of protection to other areas of life. There are some states and cities that already have passed local ordinances that extend this right to trans people, and these ordinances would not be overturned by this decision. But the rest of the trans community could easily find themselves fired with being trans as a reason for their firing. What would be our recourse? The next hope for trans people would be a further passage of local laws and a push for a national law to extend protection. It will be a fight, since bills such as this have been passed by the House of Representatives, but so far none of them have made it past the Senate, and none are likely with the current political makeup of the Senate. I am sorry, I wish I could give better news about this. I started reading it all because I got worried and got tired of seeing all the different ideas and people not sure what was going on. I hoped I would see better news when I did the studying, but I didn't. I will say this one affected me more than normally. Normally I can look at some hate that someone's written about trans people and just brush it off, think of them as classless, ignorant people. But this one has made it to the Supreme Court, and the way it's passed could really hurt a lot of people I love, myself included. I wish there were better answers. If you want to talk to me, I'm on Twitter at atheist_T_girl. And if you want to help support me, I have a PayPal, and I'll put a link in my notes. And generally right now, I hope you have a good day is what I end with, but I don't feel like doing that at this moment. I will suggest that if you made it to the end, and you know a trans person who's unsure what's going on, please forward this to them. I'm not saying that because I want to get more views. I just want other people like me to know what's happening and be ready for it. Thank you. I also want to thank Stephanie, Sheila, and Nisha for helping me. They are 3 lawyers who agreed to review what I'd written and give me some advice. Anything good that I put in here, part of it's from them. Anything wrong I put in here, it's from me, so don't take it from them.